Welcome to our exploration of the law of sale, a fundamental part of everyday transactions. Whether you're buying a house, a car, or even a smartphone, you're entering into a contract of sale. But what exactly makes a contract of sale valid? At its core, a contract of sale is an agreement where the seller commits to transferring a thing, known in law as the res vendita, to the buyer, who in turn agrees to pay a price. For a contract of sale to be valid, two essential elements must be present: agreement on the thing being sold and agreement on the price. These contracts can cover both tangible items like laptops or houses and intangible ones such as company shares. As we move forward, we'll break down the duties of both sellers and buyers and look at how risk, profit, and ownership are transferred. Let's start by understanding when a contract is considered complete or perfecta and why that matters. Now let's delve into the crucial concepts of risk, profit, and ownership in a contract of sale. Did you know that risk and ownership don't always pass to the buyer at the same time? According to common law, risk passes to the buyer once the contract is perfecta. That is, when the price is fixed, the property is ascertained, and any suspensive conditions are fulfilled. For example, if you buy 100 beads from a large bag, risk only passes once those beads are counted and set aside. Ownership, on the other hand, requires delivery and payment or credit being granted. The law presumes sales are for cash unless proven otherwise, and ownership usually passes on payment and delivery. There are also different types of delivery, from actual handover to symbolic gestures like handing over car keys. Understanding these distinctions helps both buyers and sellers know their rights and responsibilities at every stage of the sale. Let's turn our attention to the specific duties that the law imposes on sellers and buyers. Sellers have several key obligations. They must take care of the goods until delivery, deliver the goods in a deliverable state, ensure the buyer gets free and undisturbed possession, avoid making false statements, and take responsibility for latent defects. For instance, if a seller knows about a hidden defect and fails to disclose it, they could be liable, even if the contract includes a Vollstutz or as-is clause. On the buyer's side, the main duties are to pay the purchase price, accept delivery, and reimburse the seller for certain expenses if necessary. If buyers fail to pay or accept delivery, they may be in breach of contract, giving the seller grounds for legal remedies. These mutual duties ensure fairness and clarity in every sale, protecting both parties from unforeseen issues. Beyond common law, various statutes provide extra protection in specific types of sales. For example, the Alienation of Land Act requires written contracts for land sales and offers a cooling-off period in certain cases. The Sectional Titles Act and Property Practitioner Act ensure transparency and proper disclosure of defects in property transactions. Sales and execution, electronic transactions, and consumer purchases are also regulated by specific laws like the Electronic Communications and Transactions Act and the Consumer Protection Act. These laws set out additional rights and remedies for buyers, such as the right to cancel under certain conditions or claim damages for undisclosed defects. Auctions, too, are governed by both common law and consumer protection regulation. By understanding these statutory protections, buyers and sellers can navigate complex transactions with greater confidence and security. Wrap up: the law of sale is built on clear principles that protect both buyers and sellers. A valid contract of sale requires agreement on the item and the price, and the passing of risk and ownership depends on specific legal requirements. Sellers must deliver goods in good condition, disclose defects, and avoid misleading statements, while buyers must pay and accept delivery as agreed. Statutory protections add another layer of security, especially in property, electronic, and consumer sales. By understanding these rules, you can make informed decisions, avoid disputes, and ensure your rights are protected in any sale. Whether you're buying your dream car or selling a house, knowing the law of sale empowers you to handle transactions with confidence.